Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. Now, if you have a retirement account, these latest changes to the Secure Act are especially important for you. What do these legal updates mean for you and your savings? Attorney Bob Mannor will be discussing that today and more. But before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. If you have a general question during today's presentation, please use the question box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we'll contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent to you tomorrow so that you can rewatch it and of course share the video with family or friends or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Mannor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He's currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And of course, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now with that, I would like to welcome attorney Bob Mannor.
Hi, folks. So this is always an interesting topic. And so we scheduled it right now because there had been some new regulations that had been put out by the IRS. One of the things that was interesting about this new law regarding retirement assets was that it was passed into law in the last week of December of 2019. And it took effect January 1st of 2020. So there wasn't a lot of time for the IRS to adjust to it. And they took a long time to issue regulations, and they're still taking a long time to issue regulations. So we've worked out what we believe is most of it, but then they issued a proposed regulation in April, early April, that we thought that we should let you know about. And so it's interesting because they might be pulling back on that new proposed regulation. So it's an ever-changing landscape, and it's why you need a good estate planning attorney that's going to keep you informed and be up to date on these things. This is not an area for somebody that doesn't keep up to date on everything, because significant changes occur and it could cost you thousands or tens of thousands, sometimes hundreds of thousands of dollars in extra taxes if you don't have it set up right. So we're going to talk about this. What I'm going to do today is we're going to talk about what I mean by retirement assets, just kind of a recap for anybody that needs to make sure that they understand why is there a difference between what we call retirement assets, or what I'm calling retirement assets, and other assets. Like your house wouldn't be considered a retirement asset. Your IRA would be considered a retirement asset. Another term for retirement assets is a more specific term, is what they call qualified assets, qualified funds, qualified annuities, qualified accounts. And so we're going to talk about those, why they're different, why we have to be careful about them from an estate planning standpoint. Then we're going to talk about this new law, and then we're going to talk about what the proposed changes were that may or may not actually happen. So that's the agenda for today. So let's start off with what's a retirement asset. So a lot of people don't make these distinctions. Some people do. They think about it from the standpoint of a retirement asset as anything where they have not paid the taxes on yet. But that's a little bit confusing, because retirement assets also would include a Roth IRA, and a Roth you have paid the taxes on. So that's not a great definition. And then there's other accounts where it's got accumulated income that we have not paid the taxes on, but we pay taxes on the principal, and that's not considered a retirement asset. So I'm really only referring to those things. Typically, they were done to be able to either take a tax deduction when you put the money in, or not get taxed on it if it was set up by an employer, like through a 401k or 403b, any of the employer provided retirement plans where you contribute, they contribute, or any variation of that, and any rollovers from that. So a lot of people, they have this account through their employment, and then when they retire, they roll that over into an individual account or a qualified annuity or something like that. And so any variation on that. Sometimes people have rolled those over and then done a conversion to a Roth. Well, that's still a retirement asset, even though you had to pay the taxes on that conversion to the Roth. The difference with the Roth, of course, is that once you pay the taxes and it's converted to a Roth, or you contribute money to a Roth, you actually don't pay any taxes on the gain. So the longer it's in there, the better it is, because if it's in there for 20 years, you've got lots of time that you've let that account grow tax-free, and even when you pull the money out, you don't have to pay the taxes. So most traditional IRAs, 401ks, 403bs, all those types of PSPs, if you worked at GM, all those types of retirement accounts, when you start pulling the money out, you got to pay the taxes on the part that you pull out. Why is this important from an estate planning matter? And so the reason why it's important from an estate planning matter is that we got to worry about the taxes. And not only, even if it's a Roth, we got to worry about the taxes. And the point of it is with a traditional IRA, a traditional 401k, where we haven't paid the taxes on it, eventually we're going to have to pay the taxes, even if you're not living anymore. So some of you may know that in Michigan in particular, there's not really a death tax for most people. Unless you're over the $12 million mark, either federal or Michigan, you're not going to pay an estate or death tax. But where the big taxes come in is on those retirement assets. And not handling that properly can make a huge difference in what percentage of it we end up paying to Uncle Sam. What percentage of it goes to your family, what percentage of it goes to the government, okay? And a lot of people don't really talk about this. Financial advisors don't really talk about this. They say, oh, we'll get with your kids after you die and we'll give them advice. A lot of lawyers don't get involved in it, especially a lot of estate planning lawyers don't get too involved in taxes and things like that. And the reality is this is a big issue for planning, because it can make a huge difference in how much money your family gets and how much money the IRS gets. So planning for the retirement assets is particularly important. What's come about now, and this is so more important than ever after 2020, is that a lot of the planning has to occur after your death. And so it's not just the financial advisor giving those options. We've got to look at, in order to get the best possible plan, we've got to look at each of your kids individually and give them advice individually based on what their circumstances are, okay? And so historically, the lawyer kind of gets involved at the beginning of the process and and tries to predict the future and plan for how are these retirement assets going to be received, what do we think there might be left, trying to predict when you're going to die, how much money you're going to have, what your kid's situation is going to be, all things that we can't predict. That's not possible. But under the Secure Act, this new law that came about, it actually provides us with the opportunity to put off a lot of that decision until we know those things, until we know when you died. Now, it's not automatic. It's not automatic in that a lot of your estate plans are not that flexible. If you have a trust, often it's not that flexible. If you have a will, it's definitely not that flexible. If you're using beneficiary designations, it's often not going to be that flexible. And so what I'm suggesting is, in the planning that we do for our clients, we build in that flexibility so that we can take into account all of the relevant factors of when you die and how much money there are, what the kid's situation is, which kids survived you, because it's possible that not all of them are going to outlive you, whether or not we would want it to go to the kids or go on to the grandkids, because it'll save us a bunch of money in taxes, but not making you make that decision, letting your child make that decision. So if it comes about where you pass away and they're going to receive $200,000 in an IRA, they may say, well, I don't want to pay the taxes on $200,000. I'd rather have my kids pay the taxes on $200,000, and they're going to pay a lower rate of taxes, perhaps, but that's not true for every family, right? So what I'm getting at is now it's more important than ever to have qualified advisors that aren't just going to be able to advise you and set this up, but are going to be around for your kids to advise them when the time comes. Because a lot of the decision making, if you're going to want to get the best answer and not end up paying tens or hundreds of thousands of dollars more in taxes, you're going to need the advice and the decisions to be made at the time of your death. Okay, well, we don't know when you're going to die, hopefully. And so that's where it's really important. I had a question recently that one of the other lawyers here had gotten a question about just doing form documents on the internet. Well, form documents on the internet can't advise you, and they definitely can't advise your family after the fact. And so having that set up in a way that you're going to get the best setup now and also have it set up so that your kids can get the proper advice. And honestly, it's not going to be the same advice for each of your kids. Each of your kids are going to be differently situated at the time, and they're going to need specific advice as to how to minimize those taxes. And that's what we're here for. That's what we've built our system for. That's what we've built our structure for, to make sure that over time we're going to be there to help them make those decisions and give them advice with regard to that. Because sometimes it can make a huge difference between paying 40% in taxes on those IRAs and paying less than 10% in taxes on the IRAs, and just structuring that properly. So that's, sorry, I'm switching between slides real quick. So that's what a retirement asset is. A retirement asset is going to be your 401k, your IRA, your PSP, even your health savings account is considered a retirement asset. And then, of course, the other category is Roths, where you've already paid the taxes. So pretty much anything that has, if you're over 72, if you have to pay a required minimum distribution, that's a retirement asset. Anything that's a Roth also would be considered a retirement asset, and those you don't pay required minimum distributions. All right, so let's take a look at this. So what is the Secure Act? How did that change? So as I mentioned, the Secure Act passed, and it was interesting if you had paid attention to any of the messages that we send out on our email list, or some of the conversations that we had throughout 2019, there was an expectation that some version of the Secure Act was going to get passed. It had support from both parties. And so at one point in early 2019, it passed through Congress with 99% of the people voting in favor of it. And yet then it stalled and it didn't go anywhere. And so, if you remember 2019, there was a little bit of political gridlock there, and so things weren't happening. And so I had come to the conclusion by November, December that, okay, this thing's just dead in the water, even though people want to pass it, it's just, politics. So it turns out that in the year, the close, sometimes the politicians, they need that pressure to get something done. And so at the end of the year, they passed a bunch of legislation, and this was one of them. And the president signed it in late 2019, took effect January 1st of 2020. That's going to become relevant as we talk about how the IRS is now issuing new regulations with regard to this. So many of you may understand this, that most of the real laws aren't passed by Congress. And what I mean by real laws is how things actually work in real life. So a good portion of the way that we live and the way that government regulates us and things like that isn't found in the statutes themselves. A lot of it's built into the federal regulations. Okay, so it's the bureaucracy that creates the specifics of how we're going to interpret that law and how we're going to use the law. So the Congress passes and the president signs a statute, a law, and then it has to be interpreted. It has to be the bureaucracy then puts the details in it. Okay, and so some of you may think, well, that seems kind of crazy considering some of these laws are 10,000 pages long. But those 10,000 pages long laws probably have 100,000 pages in regulations that end up eventually getting associated with it. But that takes time. Obviously, the bureaucracy is going to take some time to do that. And they're constantly tweaking that. We're constantly adding new levels of bureaucracy and new levels of regulation and red tape. So you think about something like Social Security. Well, how long has Social Security been around? Where they're constantly changing those Social Security regs and updating them, and sometimes contradicting themselves and going back and forth. This is why, it's one of the unfortunate reasons why lawyers and accountants exist, right? Every time that they claim they're going to make something more simple, it typically means I'm going to need my accountant even more that year. If they say they're simplifying the tax code, it usually means, okay, I know I'm going to have a larger accounting bill this year. But that's the idea. A lot of laws are, most laws, the details are going to be in the federal regulations, the bureaucracy. So the Secure Act is designed, there was a couple things that would affect you during your lifetime. Primarily, they raised the age for taking required minimum distributions to for a little bit, not very much. But the bulk of what I'm concerned about as it relates to the Secure Act was what happens after you die, okay? What happens to those accounts? How are those accounts going to be taxed after you die? So that's what's important to me about the Secure Act. So when this passed, we took a little bit of time to absorb it and plan and strategize and then draft new legal documents. But we offered it to all of our existing clients, and we strongly recommended that our existing clients come in and make changes to their trusts for those people that had a trust, because we wanted it to get the new advantages but also comply with the Secure Act. If we don't comply with the Secure Act, it could be very possible that you end up, the kids, not you, but the kids end up paying more in taxes on those retirement accounts. And it's likely that they wouldn't have all of the options available to get the best tax results with a little bit of strategic planning, okay? So that's the idea of the Secure Act, and I have a graphic here that I've gone over that I think found interesting. For the most part on the Secure Act, there's gonna be 3 different options about how your kids are gonna get taxed. And I saw this from this advisor here. You see his name at the bottom, and he had divided like a stoplight, red, yellow, and green. And I thought this was the clearest explanation I'd seen, so I kind of have been adopting it and explaining it this way to everyone also. So the red, yellow, and green. We want to avoid the red. A lot of people are going to be in the yellow. If possible, we'd like to be in the green. And this is all about how long we have to pay the taxes on those accounts. So if you're over 72 and you have a IRA, a traditional IRA or 401k, any of those types of things, anything except for a Roth, you will know that you have required minimum distributions. In other words, you have to take money out every year and you have to pay the taxes on the money that you take out every year. And there's a required minimum that you have to take out. And so then the question is, under, what happens when you die? What happens, how do you take the money out then? Well, probably the worst case scenario is you just take all the money out and close the account and empty it and pay the taxes on all of it. Well, that's probably going to be the worst case scenario, because now you're paying all the taxes in one tax year, and probably the kids will end up bumping themselves into a higher tax bracket. They lose whatever advantages of the Roth, they lose whatever advantages of the IRA, any of that, the advantages of growth without taxes, right? But the bigger, that's a big issue, but the bigger issue is bumping themselves up into a higher tax bracket where they're taking out 40% in taxes instead of 10% in taxes, or whatever the scenario is. So what the Secure Act does is they've kind of divided it into 3 things. So the first option is that they have to pay the taxes over a 5-year period of time. That's what we want to avoid. That's the red section. So ideally, we don't want that. Some of your trusts, if you have your IRA going through your trust and it doesn't have the provisions in there that's going to be in compliance with the Secure Act, they may end up with that, and they are in the red category. That's why I was encouraging people, all of my existing clients, we contacted them. I was encouraging them to come in, let's make changes so to make sure that your kids don't end up in that red column where they're paying way more in taxes. Many, in fact, most probably, if you've done any research on the Secure Act, most of the things that people are talking about is just the yellow section, the 10-year rule, that we got to pay the taxes over 10 years. Or we have to conclude the Roth benefits after 10 years after the death of the parent or death of the original holder of the account. Well, that's particularly important when it comes to Roths, because remember, the longer it's in the Roth, the more you're going to get tax-free. It's a huge benefit. And so if we can, we're going to want to extend that out as long as possible. But what a lot of people don't realize, and what we've been trying to educate people on, is there's this whole green column. And the green column says we can go longer than 10 years. We can even go for the whole life expectancy of the person. So imagine if you had this go to a grandchild who's 20 years old when they receive this, and they can now have this over their lifespan that goes through whatever age they grow to. If it grew over 60 years, that's going to be a huge amount of money. If it was in a Roth, it could be a huge amount of money tax-free, could make a tremendous difference in their life. Now you'll see that it has to be specific circumstances, which we don't know if they are going to meet those specific circumstances. Why do we not know if your children or grandchildren meet into these specific circumstances? It's because you're not dead yet, right? We don't know when you're going to die. We don't know what's going to happen between now and then. So we have to build your legal plan to make sure that it's flexible enough to deal with that. So if it's a minor beneficiary of the decedent, if they're a disabled person, if they're chronically ill, this is one of the things that the IRS is going to have to flesh out for us, because I don't think we have a clear enough definition of what chronically ill is. But there's a whole lot of people that are considered, that I would consider chronically ill. Would they be able to get these tax advantages? Not more than 10 years younger spouses, and then certain trusts. And the idea here is this is going to be something that's going to potentially give them a huge tax advantages, but we're not going to know until you die, right? And so we have to build in these options, these green options, that could end up giving some or all of your kids significant tax benefits, okay? So I went through all of this in a webinar back last year, probably about this time last year. We started educating people about the Secure Act. This is kind of a recap of what's been done there. One of the reasons why we decided to schedule a new one was because recently the IRS had come out with some new regulations or proposed regulations. Now, remember, those were proposed regulations. They're not law yet. They're not part of the bureaucracy yet. They're not part of the regulations. But it was all about what happens after you die. So for inherited IRAs and inherited Roths. Now, just to be very technical about this, why do I limit it to inherited IRAs and inherited Roths? Why not inherited 401ks? Why not inherited 403bs? Why not inherited qualified annuities? And the answer is that when you die, it has to be converted to an IRA. It'd be converted to inherited Roth or an inherited IRA. So even if it was a 401k, even if you left it in your employer plan, it has to leave that employer plan. It has to get rolled over into an inherited IRA upon your death. So really it comes down to what's going to happen with the taxes on inherited IRAs and inherited Roths. And the new regulation that came out was saying that they were going to be required to pay minimum distributions based on their life expectancy every year, regardless of whether they're in red, yellow, or green. And that's not the way I interpreted the law. That's not the way just about everybody else interpreted the law. We all thought that if you have 10 years, if you're in that yellow column and you have 10 years, you could choose not to take out anything for 10 years and pay all the taxes in 10 years, or end the Roth in 10 years and not do anything in between. And that would be perfectly acceptable. And what the IRS said is, no, that's not the case. In fact, we're going to make you take out minimums. So not 1/10 of it. They're not saying they were going to make you take out 1/10. They were going to say required minimums based on your life expectancy. So they were going to determine that figure based on your life expectancy. If they thought you were going to live 82 years and you're 67, they were going to be a figure where they would say, well, you have to take out 8% or whatever it is. I'm not going to do the math there, but the bottom line, you have to take out a percentage every year and pay the taxes on it. And then when you get to year 10, you have to take out the bulk of it if you ended up in that yellow column. If you ended up in the green column, then we'd have a much longer period of time. If you end up in the red column, you would have had to take out the rest in year 5. So now it appears that the IRS is kind of pulling back on that. So we don't know if that is going to be the final regulation. It seems extremely likely to me at this point that they're pulling back on that, and again, going likely, again, we won't know until we know, but saying that it does not require minimum distributions during that period of time. So prior to the Secure Act, even Roths inherited Roths had required minimum distributions. So people got confused by this sometimes because they said, well, I have a Roth. I don't have any, I'm 80 years old. I don't have any required minimum distributions on my Roth during my lifetime. And that was accurate. But when you died and you left that to someone else other than your spouse, the spouse had a spousal rollover, and that still applies. So the spousal rollover will still be there. But when it goes to the kids, before the Secure Act, it was clear that they still had to take some money out of that Roth every year. Even though they didn't have to pay taxes on it, they were required to take minimum distributions out of the Roth after your death every year based on their life expectancy. Now, under the Secure Act, it is uncertain whether they're going to have to take out money every year, or they can wait until the last year that they're allowed to take it out and take all of it out, which would be the very wise choice if it was a Roth. Why? Because it continues to grow tax-free. You have all those many more years of tax-free growth that you'll never ever pay taxes on. It's almost, it's too good to be true almost, and it is true. And so the idea for most folks, and how many of your kids are going to know that that's the thing, that they shouldn't spend that money, that they should keep that inherited Roth IRA and keep it till the very last minute and then take the money out? Most of them aren't going to necessarily know that. That's why they need advice. Or whether it's the opposite. We don't know what the IRS is going to say right now, or it could be the opposite where they say, okay, well, we're going to still be able to keep 90% of it and take that out in year 10, but we'll have to, take out some of it each year. So that's something that still has to be determined. But the real point on this is the importance of making sure that you've got an advisor that can give, that's available to your family to make these decisions. And humbly, I'm saying that advisor should be us. And it is true that there's some great, really smart people out there that are doing some great things with this. But not everybody. Not everybody really gets into the tax part of it. Not everybody gets excited about this stuff like I do. I get excited about it to make sure, hey, we've got a planning opportunity. Let's take it. Let's make sure we're prepared. Let's make sure that we're doing the best that we can for our families. So that is the ins and outs of it and what we know so far on the Secure Act. And Savannah's going to come on here in a second, and she's going to give you an opportunity to ask your questions, whether it's about the Secure Act or anything else that we do, anything involving taxes or estate planning, anything involving protecting your assets, even protecting your assets from nursing home costs and things like that. What about, dealing with Alzheimer's and dementia and all those types of things. So if you have questions, Savannah's going to come on and give us some instructions here.
Thanks, Bob. And thanks everyone for joining us today. As Bob mentioned, we do have a couple of easy ways for you to contact our team, whether you would like to talk about the Secure Act or other questions or concerns, we're here. So of course, you can always give us a call. We have a local number, and of course, we have a 1-800 number. Our 1-800 number is 1-800-990-6030. You can also give us a call locally, 810-694-9000, and we're standing by to help. Now, if you're not at a point where you can call right now, but you still want to talk to our team, there's also a link. I put this in the chat. You can click that link. It will take you to a calendar. You'll choose a day and a time that's convenient for you, and a member of our team will call you then at that time that you've chosen. A lot of people take advantage of that option, and it's a great tool. So if you would like to speak with our team, just not now, go ahead and click that link, select a day and time, and then set it and forget it. We'll give you a call at that time. I'm also sending an email in probably about 15 minutes. The email will have the same thing, our phone number. It will have that link for you there too. And then tomorrow I'll be sending the replay of today's presentation. Thanks again for joining us. It's always a pleasure. We look forward to seeing you again next week.